pray for adjournment, Lordship.
37.
Yes.
The prayer of the council lists the matter again on.
My Lord, there is an interim, maybe continue, my Lord.
My lord, 37 in this case.
Anyway, you can give a date. In order passed earlier to continue.
Interim maybe continue.
Yes.
Deeply obvious, my Lord.
May I please, Your Lordship. Your Lordship, with due consent of the other side, Your Lordship, I like to mention item number 18, Your Lordship. Admission matter. Finally, this matter be adjourned for the day.
Same order. Any
Date-
interim?
Date may be fixed, Your Lordship.
Any interim is there? No.
No, Your Lordship.
Item number 50, Lordship. Possible for a day, Lordship. Today we will take a step in this case, Lordship. I don't know.
50.
50, Lordship.
All right. Same order. Date.
May I please, Lordship. I rectified item number 38 of today's list. But my learned friend said that CD not available. The petitioner is interim, Lordship. 38.
38 CD not available. List again on. Interim order passed earlier to continue.
10th of
Date of
February.
listing.
10th of February.
Name of license.
Wait, please, Your Lordship. I beg to mention item number 44, prayer for Passover.
All right. List again on.
44. The matter may be listed after 2 weeks if possible.
For 2 weeks.
Obliged.
Yeah, please, Lordship. May I please to mention item number 22 of the daily list, Your Lordship.
20.
2. CDs not available, Your Lordship.
Order CD not available.
It may be 22. 22.
Same for a respondent, informant. I mean, P-Neo.
18 February. Highly obliged.
Hey, please, Your Lordship, I beg to mention item number 57 of supplementary list. Kindly pass over it for a day.
7. Not received.
CD received.
Received. CD is received on prayer of learned council. List the matter again on. Yes.
Lordship, with the consent from the other side, I beg to mention item number 35. Lordship, CD is not available. Let the matter be adjourned for the day, Your Lordship.
Same order. CD not
The
available.
interim may be continued, Your Lordship.
Interim passed earlier. 30.
5, Your Lordship. Obliged.
Your Lordship, I beg to mention item 42. My senior is unable to appear today. Personal difficulties. The matter may be after 2 days, my lord. Take it.
CD received, my lord, item number 40.
Already. List again on. Wednesday.
After 2 days, my lord.
Wednesday.
Lord.
May it please the Lordship. My Lord, I beg to mention item number 27, my Lord. I may be allowed to withdraw, my Lord. I've been instructed charge sheet has been submitted, my Lord.
Item number 27 on the prayer of Mr. Sam Abdullah. The matter is dismissed as withdrawn.
Obliged, my Lord. But another mention, my Lord, a little bit unusual. My Lord. Actually, my Lord, what happened? My Lord, matters, my Lord, the two matters are fixed on, my Lord, 28, my Lord. But in the meantime, my charge sheet has been submitted and co-accused pertaining to the same forwarding report, same date of arrest. They have been granted bail and my bail is fixed on 28. Can it be listed tomorrow or day after tomorrow? My Lord?
8. Already day after tomorrow.
Obliged, your Lord.
May I please, Your Lordship? I beg to mention item number 56. My lord, my senior is out of station here, my lord. So matter may adjourn for a day.
56. List again on.
Obliged.
11 February.
May I please, Your Lord? My Lord, item 55, my Lord. Matter relates to my Lord check bounce case, my Lord. Matter has already been settled. And one installment is remaining, my Lord. And we'll clear that due, my Lord. So I have taken consent, my Lord. Lordship may adjourn this matter, my lord.
Is submitted on behalf of the respondent. You are appearing for.
No, I am for petitioner.
Petitioner that the matter is under settlement session and it is expected that the dispute will be resolved
Within 1 month, my lord.
within a month. Hence, list the matter again on.
Obliged.
Item number 1.
My pleasure. But petitioner arrested on 23/12/2025, my lord. He is, my lord, today is the 31 days is behind the bar, my lord. Lordship will find FIR at page 18, my lord. 18, my lord. The allegations is, my lord, the informant and his friend, my lord, while enjoying the picnic at Hatisila, my lord. The allegations is, my lord, the listeners, my lord, has attacked, my lord. My lord, in fact, my lord, we have also lodged an FIR, but that has not been registered. And subsequently, we have lodged the complaint before the, my lord, Commissioner of Police, my lord. And the alleged incident took place in the paddy field of the petitioners, my lord, not in the picnic spot. So far, the injury part is concerned, the picnic spot of Hatisila, my lord, is my lord, hill, banks of the river Brahmaputra, my lord. So while running from the paddy field, my lord, there is every possibility that he fell down in the, my lord, the hole of the, my lord, stone, and that may occur, my lord. And my FIR, lordship will find that page 23, my lord. That has not been registered. Subsequently, complaint has been lodged before the, my lord, Commissioner of Police. And the real fact, my lord, the informant and his, my lord, colleagues, my lord, unauthorizedly entered into the paddy field of the petitioners, and they use slang language to the women who are, my lord, who work in the paddy field. The petitioners was not present at the time, my lord.
It will have the CD. Kamrup shortly.
On the 28/1. 27 one.
My lord, item 14, my lord, it is arising out of the same, my lord, affair,
Item 14.
my lord. But, my lord, that is AB, my lord.
Have the CD then.
But, my lord, till then, my lord, because,
Then we have to hear, wait for the item.
my lord, my lord. Yes.
None appears. List again on. Can call for the CD also.
Oh, yes.
Call for the CD. Okay.
Mayor Lordship. Lordship 43 application Lordship. Lordship FIR phase 10 Lordship. 51 days behind the bar Lordship as in today. Kindly please the FIR phase 10 Lordship. Vehicle already been recovered Lordship, given Zimma to the its owner Lordship. FIR phase 10 Lordship. Allegation stolen of a vehicle Lordship. Vehicle recovered and given Zimma to its owner Lordship. So further custodialization may not be required Lordship.
Bolero.
I have another seizure list of the lordship. Kindly press annexure 4, page 19, lordship. It's 19, lordship, type copy, lordship. Description of seizure, lordship. One vehicle, Bolero Mahindra, Scorpio so and so.
Seized from you.
Yes, lordship. Then lordship, it's given to that owner, lordship. Kindly press page number 21, lordship.
So you are fully implicated.
Already recovered, lordship, but given Jimma also, lordship.
Yes, PP.
On 3rd of February, man. On 3rd of February, man.
Lordship, already 50 days.
Because
50 days.
Jimma granted to the owner, that is a different aspect, but those vehicles were recovered from the possession of the present accused person. And thereafter, my lord, from the earlier rejection order, my lord, it reflects that findings, my lord, sufficient material against the accused. There are 305
So
also.
it
my
was
lord.
earlier rejected.
Yes.
All right.
60 days.
Well, I have it in 4 or 5 days.
50 days, lordship. As in total of 50 days, lordship.
It is then, my lord, on 29/1. 29.
All right.
How left?
Meet pleasure, Lordship. This is a 483 bill application, my lord. Petitioner was arrested on 18/12/25. Now 42 days, my lord. FIR type copy of the FIR is at page number 11, my lord. Translated copy, my lord. May I read? May I read? With due respect, this is to inform you that for about a year from today, one C. Raymond Moran, son of so-and-so, a resident of so-and-so, has been mentally and physically harassing my sister so-and-so under the
All right,
pretext of
CD.
law. My lord, I am alleging that, my lord, ground of, sorry, my lord, notice does not contain the signature of the, my lord, witness, my lord. And this is in similar
The
cases.
CD will reveal
Sorted.
whether you have been apprised of it or not.
2nd of February, my lord.
Bless you, sir.
My lordship, my lord, may kindly see FIR page 10. From the FIR, it appears that the alleged money, that is rupees 2 lakhs, 1 lakh Bhutanese note and 1 lakh Indian notes were seized. But here in the FIR, it is written that it was recovered from the accused persons, but in the bail rejection order, that is not mentioned. Neither seizure list was given. Our instruction is that, my lord, the money was recovered from third person, not from these two persons. And we are behind the bar since last 22 days.
It was rejected after perusal of the CD. We'll have to see the CD.
Expect
the
a
CD.
short date because already money has been recovered from third person's possession.
Possession, it may be recovered from third person. It doesn't mean you are not involved.
3rd of February.
February.
Please, your lordship. So charge sheeted case, my lord, murder case, so scan copies may be called for, my lord.
Call for scan copy of the TC. Since charge sheet has already been submitted.
Around 30th. 30th person. Deeply operating.
May I please, your lordship? This is a 482 application for granting bail to the accused person. Lordship, the FIR is at page 20, actually 17, but 11 portion is as in page number 21, Lordship. The file actually, Lordship, this is a totally false facts stated in the FIR, Lordship. The actual fact is that, Lordship, the domestic servant engaged by the informant uh, sought help from the neighbors of the locality that she has been continuously raped by the informant since the day of her engagement as domestic help. Hearing all these facts, the people came to inquire, the neighbor of the locality came to inquire about the facts. On the way, they were attacked by the attacked by the informant and his associate. Ashif, FIR has been kindly and see annexure 2, page 223. Myself, we have been beaten to we have been Lordship assaulted. Kindly see the annexure 9. All the medical certificate which I have annexed, kindly see. And then especially the that is annexure 9, that is the accused number 2. He's the doctor has advised him to open the stage after 8 to 10 days, but could not come because the police personnel are visiting now and then. Kindly interim may be considered. And the police refused to register our FIR. That's why we are compelled to file a logic complaint before the commissioner. You should kindly see my medical documents from page 20, annexure 3, page 26 to annexure 9, page 32. I'm the sufferer. I've been assaulted. All this false flag. When I went to register the FIR, Rashid, that time the police refused to register any FIR against me. But after 1 hour, the informant, when he went to the police station, that time he was his FIR was registered.
Why is your nickname Tablet? What kind of tablet is it? Hmm?
They kindly consider the interim bail, Lordship, otherwise, because I need to have a treatment because my from my wound the pools has come out. It's very difficult. Otherwise, it will take it will become a fatal for me. And this is annexure 9, Lordship. I have been assaulted, but they have made false facts in the FIR. They have managed the police also, Lordship.
Yes, PP.
Otherwise, my lord, whether the story of the petitioner is true or false, only CD will otherwise reveal. But my lord,
Till
here,
that, Lordship.
here they stated that they, my lord, along with some other person, went to the residence of the complainant Azmal Ali regarding that, my lord, he is involved in committing, my lord, rape to one of her maid servant. But regarding that aspect, why that affair, my lord, now they stated that that affair was not registered by the police. But
They refused to because they police refused to register
but
because
they lost
first
that.
we went there to register the FIR, but police refused to register our FIR.
But
But
regarding
after 1 hour, They register the FIR
But
of
regarding
the
the
informant
allegation
only.
in the present FIR, only CD will reveal, my lord, along with.
Till that time, we may be considered for
Supplementary
interim
report, my lord.
lordship. Till we may be considered because especially the accused number 3, he need to have a treatment because after 8 to 10 days, he was asked to open the stage, but his wound is so much fatal that it's pooja is coming out. Lordship, it may cause death to him also.
Who is that?
Accused number 2.
Name?
Sure.
Sirajul.
Sirajul Ali. Alias Tuklu Ali. All the 4 are already been injured because
Heard
Lordship,
on the
I have
counsel
released
for the
all the
petition
medical
under
documents.
additional PP. This is an application under the allegation as contained in the FIR. The present petitioners act the complainant and his family members and caused grievous injuries to them. Also snatched away an amount of rupees 75,000. It is submitted that on behalf of the petitioner that was the complainant party that had attacked the petitioners when they had gone to inquire about the complainant committing rape upon his employee. And in this regard, they had submitted an FIR, but the same was not registered by the police. The FIR is annexed as Annex 2. It is also submitted that the petitioner number 2 has been seriously injured and is under treatment and may be granted interim protection so that his treatment may continue. Para call for the CD. The interim, it is provided. Petitioner number 2, event of his arrest in connection with so-and-so shall be released on interim pre-arrest bail of rupees 3,000 with one surety of like amount. Provided that the petitioner 2 shall cooperate with the investigation. Is the matter again on
17-2.
Objection.
May I please, your lordship? My lord, 482, my lord, pre-arrest bail application, my lord, may straight away can come to the FIR, my lord, is at page 17, my lord, last page of my petition. Section 69 only, my lord, the BNS had been added.
yes?
My lord, both are major, my lord, adult and consenting parties. But my lord, due to some discrepancies, my lord, these allegations had been leveled later on. Because my lord, in fact, the boy, my lord, the petitioner, my lord, is lesser in age than the present informant, my lord. And the whole allegation, my lord, which has been brought in, my lord, I have come to know, my lord, that she had a relationship with the other person also, my lord. So therefore, there may be something there. But dispute is there, my lord, and there is no, my lord, disclosure my identity. She knows me very well, my lord. My name, my identity, even she went to my family members also, my lord. So, my lord, at this moment, my lord, may I humbly pray, my lord. My lord can call for the case diary, my lord, and examine, my lord, as I am a student. Some examination is also coming, my lord. So, my lord, may I pray that, my lord, some interim protection may kindly be provided, my lord. If material disclosures in the CD, my lord can.
Third learned counsel for the petitioner. PP. So and so. The allegation as contained in the FIR is that the petitioner was having sexual intercourse with the complainant by practicing fraud. And when the complainant became pregnant, petitioner refused to take responsibility. Instead, tried to cause her abortion and also tried to kill her by violation. It is submitted on behalf of the petitioner that both the petitioner and the complainant are adults and they were in a consensual relationship, and subsequently differences developed between them. Has lodged the FIR, certain false allegations. Call for the C. 50,000 rupees. List again on
29th, my lord.
My lord, interim has been given me. My lord, highly obliged, my lord.
May please your lordship. Here, my lord, at this case, my case diary may be called for, my lord, from Nagaon, my lord.
ID.
Please your lordship. Nagaon, my lord, short date may be peak, only that prayer, my lord.
29, my lord.
Oblige your lordship.
Please, your lordship. Case 11 is the FIR, your lordship. 16 petitioner before your lordship. All are family members, your lordship. Case 11 is the FIR, your lordship. In this case, all are not present in the place of occurrence. Only petitioner 3 and 4 are present in the place of occurrence, but they implicated all the petitioners. There is no specific allegation against the petitioner. Only that accused number 1 means petitioner 1 called. Case 5, your lordship, paragraph 4. My petition, kindly, what is the actual fact, your lordship? Kindly tell us, sir. Case 5, paragraph 4, your lordship. Your lordship, my petition. What is the actual fact, your lordship? The victim, Naushad Ali, eloped with the wife of petition number 3, Rafika Bibi. And villagers caught red-handed both of them and physically assaulted. Then petition number 3 and 4, they are present. But other petitioners are not present in the place of occurrence, but due to family members or implicated, it was the elders. Court has very cooperative, your lordship. Just got red-handed, both of them.
They are FIR name, my lord.
Okay, all are family.
Earlier rejected after seeing the CD by session judge.
Lordship, internal care.
Call for the CD.
Keep a short video, because family members.
Above 28.
Publish.
May I please, your lordship? Lordship, is a pre-arrest bail application, lordship. Lordship will find the FIR on page 11, lordship. As per the allegation, lordship, may I read the FIR, lordship?
Yes.
Lordship, with due respect, I would like to inform you that the undersigned is the local representative for NCR Corporation India Private Limited. The said company is dealing with manufacturing, installation, maintenance, and operation of ATM, all public sector bank in the northeastern part of India, and accordingly we have installed, which is under our direct company supervision. For this, we are, we are
All right,
renovation
CD.
our SBI ATM user ID so and so situated at near NEF College,
Almost,
Sakusi, Lokra.
my lord. It's
After
27.
the renovation, some misconduct stole the UPS.
Yes, it was earlier rejected by, so we'll have the CD.
Lordship, the petitioner is the owner of a damp, lordship,
Yes.
and
Whatever be the case, after perusal of the CD, your prayer was rejected. You have to see the CD.
27 lords, short date from Bokisto.
deeply aware.
Please, your lordship.
Lordship, this is a 482. My lord, original FIR, my lord, directly, my lord, kindly peruse the page 19, my lord. The original FIR, my lord. May I read, my lord?
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে ৩ নং পদকেজনে মোৰ বাবাক মাটি বিক্ৰী কৰিম বুলি কৈ মোৰ বাবা জুলহাজুদ্দিনৰ পৰা নগদ ৫ লাখ টকা আজি প্ৰায় ১ বছৰ আগত লৈ কোনো ধৰণৰ মাটি নিদি পদকীয়াজনে নিজ বস্তিত ঘৰ এটা বনাই আমাৰ মা বাবা ভাই ভনী সহ ৫জনীয়া পৰিয়ালে এবছৰ ধৰি বসবাস কৰি আছে। পদকীয়া ১ নং মোৰ ভনী চাহিদা খাতুন বয়স ১৭ বছৰ ৬ মাহ পদকীয়াখনৰ বস্তিত থকাৰ সুযোগ লৈ প্ৰায়ে ভাল পোৱাৰ বাবে জোৰ জুলুম কৰি থাকে। অৱশেষত সিহঁতৰ মাজত প্ৰেমৰ সম্পৰ্ক গঢ়ি উঠে। যোৱাকালি ইংৰাজী ২/১২/২০২৫ তাৰিখে ৰাতি ১১ বজাত আমাৰ ঘৰত অকল বেমাৰী পিতা থকাৰ সুযোগ লৈ ১ নং পদকীয়াই মোৰ ভনী থকা ৰুমৰ ভিতৰত সোমাই গৈ মোৰ ভনীজনীৰ লগত আছিল আৰু মোৰ পিতাই ১ নং পদকীয়াক ঘৰৰ পৰা ওলাই যাব কোৱাত মোৰ পিতাক চিগাৰেটৰ লগত নিচা সেৱন কৰাই অচেতন কৰি মোৰ ভনীজনীক বাকী পদকীয়াজনৰ সহযোগত পানে মাৰি পেলাই গলত ফাঁচি লগাই আত্মহত্যাৰ ৰূপ দিয়ে, কিয়নো ১ নং পদকীয়া অন্য ঠাইত বিয়াৰ বন্দোবস্ত হৈছে।
Right, CD.
My lord, in this case, my lord.
In this case, your earlier
my lord-
application was rejected
No,
after
my
perusing
lord,
the
this is the
CD.
first time, my lord. This is the first time.
No,
here,
you have
my lord.
stated here, what is that?
But my lord, as a young guys, my lord, in this kindly look into that, my lord.
No, no, you are
That's-
saying first time.
My lord,
Let us verify that first.
yes, my lord. This is the first time, my lord, and the young guys, my lord, in this particular case, what happened, my lord? First part is my lord, civil nature.
What is,
Second
look at
part-
your paragraph 8. Have you read your petition or not?
My lord, in this case, my lord, in the session, just, my lord, rejected my prayer,
Then,
my lord.
why are you saying first time? It was earlier rejected after perusing the CD.
That's true, but my lord, I may
Is
be
the only
protect,
pro-
my lord, I am ready to cooperate with the, any investigation, lordship.
Everybody is ready.
From Rural, my lord. So 27, my lord.
20 session, I will be ready. Can it be 30?
30. 30.
It's the same affair, my lord, but that here is a married which he is, my lord, residing in the separate, my lord. I am accused number 2, my lord, in this particular case.
All right, same date.
Same.
My lord, particular, my lord, protection may be given, my lord. I have the married man, my lord, and but there's a no link. Only one line is there, my lord. The my lord, that affair is page, my lord, 21. The logo more phony, baki particular logo. No other allegation with me, my lord. Kindly look into that, my lord. I am a married man, and my lord, no one is, my lord, person to income in my family, my lord. So That is, my lord. No, nothing allegation against me, my lord. Only that's one line, my lord. They falsely implemented my name, my lord, in this affair, my lord. Can you look into that part, the lordship?
You
I
are
am
part
ready
of,
to cooperate.
you are part of the allegation is of killing.
My lord, I am ready to cooperate any condition, my lord, with the investigation authorities, my lord. I may
It's up to
protect,
them,
my lord, I am
but-
ready, my lord. I may be protect, my lord. No link, I was staying in a different place, my lord. My name is.
How do we note all that? It was a
My lord, I am.
concerted action.
I am ready, my lord. I am ready to cooperate any, my lord, investigation authority with any condition, my lord.
Okay, we are having it on short date anyway.
But my lord, I may be protect, my lord. Police is searching, my lord, so.
No. Yes, next.
30. Oblige, your lord.
May I please, Your Lordship. Here is bail application, my lord. Lordship will find FIR at page 18. My lord, the allegation is, my lord, the alleged incident, my lord, alleged to have been took place, my lord, in the, my lord, picnic spot. In fact, my lord, the informant and his, my lord, colleagues has entered into the, my lord, the paddy field of the petitioner, which is, my lord, far away from the picnic spot, my lord. My lord, though we have lost complaint, my lord, that has not been registered, and subsequently we have lost, my lord, another complaint before the Commissioner of Police, my lord, that lordship will peruse that page 23, my lord. The whole facts, my lord, these correct facts has been narrated, my lord, in the page 23, my lord. Petitioner
Now, how is this item 14 different from the item 1?
not different, my lord, not different, same affair, my lord.
Same order.
My lord, this is AB, my lord, my lord. This is petitioner is, my lord.
You are part of the same group.
My lord, in fact, my lord, the informant and his colleague, my lord, is drunken state of, my lord, they have entered into the paddy field. Not in the incident took place, my lord, in the picnic spot, my lord. And they have, my lord, used slang language, and my lord, they have also urinated in front of the, my lord, female members of the, my lord, petitioners. The petitioners were not present while the incident took place, my lord. That lordship will find page 23, my lord, that has been narrated, my lord. The Mandir committee also informed, my lord, they have come, my lord, 100, the members of the family, my lord, dialed 100, my lord, police came, my lord. I may be protected, my lord, I will cooperate with the investigating authority, my lord. Page 23, my lord, everything, my lord, has been, my lord, narrated that the facts, well, facts, my lord. This incident, my lord, never took place in the, my lord, picnic spot. They have, my lord, unauthorizedly entered into the paddy field of the, my lord, the petitioners, my lord, while the female members were worked in the paddy field.
Is FIR name, my lord, and my lord,
FIR name is true.
allegation is very serious, my. Pray for my lord CD, my lord. Very.
Amen.
Try to have the CD.
My lord, 27, my lord, earlier date, my lord, 27.
Yes, Mr. Lord. My lord, page 14 is the FIR, my lord. Here, my lord, 4 and 5 drunken persons. A dominance party with arms, 7 persons, patrolling party. They are condoned, my lord. And allegation is that they have, my lord, attempted to deter. My lord, how can a armed persons on the drunken stage. It is expected that they have might not use the filthy language because they are in intoxicated manner. Police can condemn them, they arrested them, but police has filed FIR that they want to deter. Now, 2 persons are given bail, my lord, page 20 B, one deposit. So custodial detention, I think they cannot deter this and coming to this and nothing to unless recover because only thing is mischief done by this. Then my lord, page 14 it says, if we count this persons, the 7 in armed persons, police department, my lord, how can 4 and 5 drunken youth, 24 or 5 years? That is expected that they use the language is because intoxicated manner. Police can arrest them that night only. However, so my humble submission is considering everything, custodial detention is not at this required. And at any terms and condition, my lord, in fortnight he may appear. Started hitting arguments, engage physical altercations. A drunken youths.
Serious, my lord. They're causing injuries to the, my lord, the delegation of the, to the police, my lord, when they are, my lord, they are in the duty, my lord. And my lord,
Because like Session Judge, after perusing case diary, has recorded that there is incriminating material against you.
Thing, my lord. One Sagar Malu, there is no specific that he want to snatch this watch or something like that. But co-accused, he was granted bail, my lord, page 20. My lord,
Sagar
no,
Malo,
FIR is not.
present petitioner is Sagar Malo.
yes, he is FIR.
No, in FIR, there is
FIR
no
is fine.
specific allegation that out of 4 and 5% he has done something. So how can this deposit, my lord, he was granted bail, my lord, because
That was
he
after
has
perusal
some
of
good
CD.
relation with
Yes.
police, my lord. So out of ego, my lord, I think police has done. But how can we presume that unarmed, intoxicated, this can do harm? They have their arms and weapons, but AB minus arms, battles, SI and all are commanded, constable, arms persons at NL 30. So presumption is that I think exaggerated manner this is done. And FIR is also not so clear how much damage or something like that. Only because he cannot, he's a poor person, cannot contact with his police. So police has not given, but others co-accused. He has given bail, my lord. Police has a favorable or CD for him. So interim order may be given if something wrong is he can cancel, my lord. He's a 24 years old and without, my lord, it's very difficult for him, my lord. If anything mentioned in this FIR, I can understand.
Allegation in the FIR is very clear, my lord. When instructed to leave the place, the person namely so and present petitioner Sagar Malu, so others started heated argument, engaged in physical altercations and obstructed our lawful duty. They ganged up and physically assaulted the police personnel, also abused using unparliamentary word, thereby causing injuries to the police party and attempted to deter us from discharging our lawful duties. So the
No,
my lord,
seven-
the allegation is very clear, my lord, and they are in allegation is that they are drunken stage, my lord.
Seven
At
armed
that-
persons.
at that point of time, my lord, it is a state, my lord, where, my lord, they don't understand who is police, who is a civilian, my lord.
That is the thing, my lord.
So-
We understand that they have armed.
Exactly,
They have
my
some
lord,
groups.
because
Then you can
Because
apprehension
of
is
that,
there.
my lord, CD is needed, very short date, my lord.
Simple police, a constable can pick up them up. Or they have the arms. My lord, this proposition are not acceptable, my lord, in practice. So interim may be given, my lord, then CD may call and CD is, the encrypting materials is there, then. Oh, one
This
is
is what has happened earlier. After seeing the CD, it was rejected.
rejected means one CD,
My lord, one co-accused is given. Police has given favorable order because,
There may not have been anything against him.
yes. My lord,
Just because somebody has been given. Cannot
then
claim parity, you
what,
can-
what type of injury, how much damage is done, nothing is divulged here. This is a omnibus statement is given. Somebody is, police is, they have good relation to police. So no incriminating materials is, in case of discrimination is there. But in what perspective, when Duncan's, 4-5 Duncan's youth and police team arms, how can it deter? They can easily, it is a dominance per team, means wherever in these days where some mischief is done, they pick up. Why have not left them? They can come a team if they are so debtors. They can arrest, put in behind this jail. Why affair, my lord? So it is out of ego or something like that, my lord. If it is like that, they deters a drunken voice, my lord, these days. This concept is like a,
Okay,
so, my lord.
Okay, we'll see. Give it date. We'll see. Give the date later.
So let me go to the last order, my lord, on 15/12/2025, my lord. The respondent number 2 has said, I have no objection if the matter is remanded back to the appellant court for decision on merit, my lord. But this time they have not appeared, my lord. Good night.
You are for respondent.
I am for petitioner, my lord.
Well, it's a complaint case, my lord. We are just a formal party.
Formal party,
Oh.
state, the formal party.
Can an appeal be dismissed for non-prosecution?
Yes, yes. It can be, my lord. On the last occasion, they have appeared and they have given already, they have given the consent, my lord. The last occasion, my lord, PK Sarma, or respondent number 2, my lord, he have appeared, man. He had appeared. Because lordship can dispose of the matter, man.
And heard. You are
He Bora, my lord.
the Bora Learned Counsel for the petitioner. This revision has been directed against an order dated 31/05/2019, whereby an appeal filed by the petitioners been dismissed due to non-prosecution. As reflected in the previous order dated 15/12/25. The Learned Counsel for the respondent number 2 had submitted that the respondent number 2 has no objection if the matter is remanded back to the appellate court for decision on merits. And the Learned Counsel for the petitioners was granted time to obtain instructions. Today, Learned Counsel for the petitioner has appeared and submitted that the matter may be remanded back to the appellate court for a decision on merits. Having regard to the same, this criminal petition is disposed of by setting aside the impugned order dated 31/05/2019 passed in posted will be NI case number 6-3 and it is directed that the said appeal shall be first page, okay, appeal number 8 of 2010, criminal appeal number 8 of 2010, pending before the session judge Nalbari. And further directed that the said appeal shall be heard on merits. And accordingly disposed of. The parties are directed to appear before the learned appellate court on given date. You have to appear there.
Yes. After 4 weeks.
Give a date after 4 weeks already.
Hello. Obvious.
Constant disposed of accordingly.
Confused, Lordship. But here, my lord, is the order under challenge is at page 80, my lord. Petition has been filed by the brother of the husband. For the husband, my lord, is the respondent. Respondent is the wife, my lord. She filed a case under the DV Act. Now, what had happened, my lord, the husband is a person of unsound mind. And my lord, at the time, the initial stage, my lord, the parents and the husband were made parties. The father-in-law died. The mother, while filing the witness statement, took a categorical stand, my lord, that the person, that her son is a person of unsound mind. And my lord, documents from 2003 were annexed, medical documents, to the effect that he is a person of unsound mind. Thereafter, my lord, the evidence was filed as well as a petition for interim maintenance. We filed an application under section 329(30) CRPC, stating that, my lord, the husband is a person of unsound mind and he is required to be proceeding as per section 328, 329, my lord, that has to be proceeded, my lord. That petition was rejected on the ground that, my lord, this is a quasi-civil proceeding and the provisions of the CRPC are not attended. This is basically the case, my lord. But, my lord, section 28 of the DV Act is very specific. It says, my lord, the provisions Service otherwise provided in this act, all proceeding under section 12, 18, 19, 20, 21, 22, and offences under section 31 shall be governed by the provisions of the Code of Criminal Procedure. So that is very specific under section 28 of the DV Act. Secondly, my lord, even if it is say quasi-civil, it amounts to quasi-criminal as well. My lord. So, my lord, that rejection, my lord, that is under challenge before this honorable court. And if your lordship, before I take you to the order, and if a reliefs, my lord, which was claimed, if the lordship will kindly come to page 33, that is the form 2, my lord. This is an application under section 12. 34 section 18, 19 and 20 where asks for
Yes.
Now, if your lordship kindly comes to the WS, which you'll find at page 40, my lord. Categorical statements were there, and in fact, from page 49 onwards, medical documents as regards to his mental unsoundness of mind, my lord, were already annexed. Now, my lord, page 56 is the petition which was filed before the court below, my lord.
So basically, only question required to be answered is whether the provisions of the CRPC sought to be invoked.
Yes, my lord. That is there. But where, if your lordship kindly takes section 28, that is what I was referring to, my lord. The petition is admittedly, my lord, as that section 12, 18, 19, 20, and 22, my lord. So, when the DV Act itself says, section 28, save as otherwise provided in this act, that proceeding under section 12, 18, 19, 20, 21, 22, 23, and under section 31 shall be governed by the provisions of the Code of Criminal Procedure. So, when there is a specific provision, my lord, only because it is quasi-civil, at the same time, even.
Yes.
My lord, my learned friend is thinking on this section 28, my lord, but he has omitted section 29, my lord. Section 29 proves that there is a provision of appeal, my lord, the appeal lies to the Court of Session, my lord. If number one, my lord. Secondly, my lord, my friend is my lord representing the stranger, my lord. Assuming, my lord, that this respondent number one for whom he has filed the petition is a lunatic or a person of unsound mind, then my lord, who is to appoint the guardian, my lord? Either he has to be represented by, my lord, the natural guardian, that is his mother, my lord. She is already respondent number two in that this DV case, my lord. She has filed the, my lord, WS. Why, my lord, she cannot represent the respondent number one, my lord, number one question, my lord. Secondly, my lord, he can only represent the accused number one, my lord, if he is legally appointed by a competent authority, my lord. And that is the district judge, my lord. District judge has the power under the Guardianship Wards Act, my lord, to appoint a guardian of a person of unsound mind or a minor, my lord. That is a very clear position, my lord. How my learned friend can, my lord, come into a picture on his own, my lord, and actually, my lord, the real fact is, my lord, this fellow, my lord, he is well settled in Visakhapatnam, my lord. Now, my lord, he has come to this area, my lord, only to sell all the properties, my lord, so that he can collect the money and go back to Visakhapatnam. Now, my lord, otherwise, my lord, he is assuming that the section 329, 330 are applicable to the. Then what is the provisions of those sections, my lord? Magistrate, take your lordship to that. My lord, the magistrate has to constitute, my lord, to examine whether the person is of unsound mind or not. Let, my lord, all these process we started. I have no objection, my lord. But, my lord, this lady, my lord, she is since 22, my lord, she is without means, my lord. Why they are not paying, my lord, anything to the lady, my lord? And, my lord, as per their own document, the respondent number one was of unsound mind since the 2014-15, my lord. If that was the position, my lord, why they have ruined the life of this lady, my lord, in the year 2019, my lord? Why they choose to marry with this lady, my lord? Now, my lord, in spite of the fact, knowing well that this respondent number one is a person of unsound mind, lord, they choose to ruin the life of this girl, my lord. And after 2 years, my lord, they are saying that he is a person of unsound mind, so he cannot. Now, my lord, there are, my lord, several property in the Vilasipada, where this respondent number are residing, my lord. This, my lord, this respondent is only claiming, my lord, she is ready to look after her husband, my lord. Now, the only problem is, my lord, the mother-in-law, my lord. My lord, if they have several property in that area, my lord, there are two or three shops, my lord. Why they cannot allow this, my lord, lady to maintain her husband in one of their property, my lord? This petition is only, my lord, with a malafide intent to frustrate this lady, my lord, so that she can come to the bargaining position that they can sell all the property, and this petition can left for Visakhapatnam with all the money, my lord. That is the only intention of this petition, my lord. Your lordship may allow that petition, my lord, subject to payment of 50,000 per month to this agreed person, my lord. They have crores of property worth crores of rupees, my lord. They have their business in Vilasipada, wholesale business, my lord. Why they can't pay anything, my lord?
No, is there any order of the magistrate?
My lord.
No.
Yes.
Any interim maintenance?
My lord,
is
when
there?
we filed the petition for interim maintenance, my lord, after the filing of it for reception liability, then this fellow come into picture, file this petition that he is the person of unsound mind. So he is not in a position to pay anything, my lord. Maybe, my lord, assuming, my lord, that he is a person of unsound mind. My lord, how long my friend will, the client of my friend will maintain him, my lord? After selling this property, he will be thrown to somewhere
These are
else.
assumptions, sir.
Yes.
These are assumptions.
This is
and
not
presumptions.
exemption, my lord.
Sorry.
This is not an exemption, my lord. No, why she is the legally wedded wife, my lord? Why she cannot be allowed to maintain her husband, my lord? Maybe, my lord, the mother-in-law have some problem with her, my lord. Then there are 2-3 properties. In one of the properties, she can be allowed to stay with her husband, my lord. We have taken this very specific ground in our objection, my lord. See, nothing else, my lord. He just want to dispose of all the property and go for Visakhapatnam. He has well settled business there, my lord. He has only come in Assam to sell this property after the death of father, my lord.
Let us take this up for, I don't think he is in a position to agree to pay 50,000.
Ready to maintain my husband with the separate.
mother-in-law-
There, my lord, some commissioner may be appointed, my lord, to look after what the property they have.
The
in
property, my lord.
Yes, my lord, why she cannot be allowed one of
No,
the
I'm
property, my lord?
failing to understand one thing. The property belongs to, as of now, since this is the father is not there, my lord, the mother and the 2 sons, my lord, as of now. Can it be sold off, my lord?
No, I'm not asking for selling, my
So,
lord.
my lord, the
No,
question of what is the
no,
question is the
why,
alienation,
my
my lord.
Why, my lord, why he?
Bogus things are being said.
Why, how it is bogus, my lord? I am just asking, my lord, that there may be a specific, I may not be, I may not be entitled to sell the property, my lord. But why I am not entitled to maintain my husband, my lord, in one of the properties, my lord?
Who will determine, my lord? In
Then
our
who will
petition, my lord,
No,
in
my
our
lord,
petition, she
let-
said.
Then, my lord,
Then we'll have a full hearing. Let us
Lordship,
fix it for hearing.
why, how he is entitled to represent this?
That is.
No, he has to be.
Petitioner. Counsel for respondent, the matter is admitted for hearing.
My lord, yes.
Hearing on.
My lord, some amount may be, otherwise, my lord, see, this lady is very.
Look, who will pay, my lord? The
No, who-
in-laws cannot be right payment. This is not the legal
No,
process.
why, my lord? Why not, my lord? When
Whom?
they are having lakhs of rupees monthly rent, they are receiving
No,
monthly lakhs of rupees.
let us have it on a fixed date and we'll hear the matter finally.
The
Not
interim, my lord. We continue, my lord.
You have been there since 24 without maintenance.
Huh? My lord.
Since 24 you have been without maintenance, so we'll take it up within given date.
My lord, yes,
1st of February.
five.
Right.
Obliged.
Obliged, my lord.
Please, my lord. Well, my lord, we filed this petition, my lord, to challenge the order of the cognizance
taken by the landed court below, my lord, in the NI Act, my lord, as well as the inter NI Act case, my lord. In this case, my lord, what happened, my lord? May I, my lord?
Yes, yes.
In this case, what happened, my lord? The complainant filed a complaint petition, my lord, before the learned CGM Dhubri, my lord, where, my lord, in this regard, my lord, that AS6 issued by this present petitioner, my lord, which was dishonored, my lord. After that, the complainant issued notice, my lord, as per section 138 of the NI Act, my lord. As subsequent that, my lord, he instituted this complaint, my lord. If lordship may peruse the, my lord, section 138 of the NI Act, my lord. Section 138B, my lord, explain the notice to be sent, my lord, within the 30 days from the date of the information of the dishonorment, my lord. After that, my lord, notice, when the notice was, demand notice will be served, my lord, then he had to wait, my lord, 15 days, my lord. In this case, my lord, notice was issued on 26/12/2023, my lord, and this present complaint filed on 8/1/2025. Sorry, my lord, 2024, my lord. My lord, if we may calculate, my lord, 26 plus 15 days, my lord, it will be, my lord, 10/1/2024, my lord. Even, my lord, without completing the period of 15 days, my lord, this present complainant, my lord, this present respondent, my lord, issued this complaint, my lord, which is a premature, my lord. This is my first submission, my lord. Second submission is that, my lord.
Yes.
Yes, my
Go
lord.
on.
Second submission is that, my lord, that cognizance order, my lord, is on lordship may comes may page on 27, my lord. This is the order of cognizance order, my lord. Order dated 29/2/2025. Where, my lord, learned court below, my lord, presume that, my lord, notice sent to the me, my lord, to serve as per clause 27 of the General Clause Act, my lord. My only submission is that, my lord, when the complainant himself is aware that said notice was not served to me, it was sent back to the sender, my lord. And in complaint petition, my lord, he categorically failed, even not whisper, my lord, the address where the notice was sent, that is the correct address of my correct address, my lord. Not even, my lord, mentioned. In that case, my lord, the cognizance for the presumption taken under section 28 of the General Clause Act, my lord, the learned court below, that cannot be, my lord, take, my lord, that presumption, my lord. That is my two submission, my lord. This is, my lord, initially, my lord, this is a premature, my lord. Only, my lord, cause of action arise, my lord, when the 15 days after serving of the notice, the 15 days period is over. If within this 15 days I paid this amount, there is no crime, no cause of action. If within 15 days I fail to pay, my lord, then, my lord, limitation start. Then only cause of action start, my lord. Before 15 days, my lord, there is no cause of action, nothing, my lord, there is. That is why, my lord, this cognizance order itself is premature, my lord. That is my humble submission, my lord. In this regard, my lord, I am prepared as judgment of this honorable Supreme Court, my lord, if lordship may. Lordship may relevant paragraph is para 35 and 36, my lord.
Yugandhar Pratap.
Para 35 and 36, my lord. Where, my lord, learned apex court, my lord, categorically stated there is no cause of action before 15 days, my lord. Only when within the 15 days I fail to pay, my lord, then only, my lord, cause of action.
Who had earlier submitted this one, other one, Gajanan Burange?
That is the same judgment, my lord.
Same judgment,
Same
it was
judgment.
referred.
It is by respondent, my lord.
Apparently, Lordship, that order of taking cognizance was erroneous because it was premature. Now, Yugandhar Pratap Singh Supreme Court has come with the solution that complainant may be allowed to withdraw his complaint and may be allowed to file a fresh complaint, and delay may be condoned because of these irregularities in taking cognizance. That was the Supreme Court has decided that in Yugandhar Pratap Singh. Now, so far notice is concerned, the Lordship will find in the complaint itself, we have mentioned both the postal receipt of sending the notice to both the addresses. Now, section 27 of General Clause Act gives the presumption that once the notice is sent in a proper with a proper postal.
Now, even if that be so, still, what about the first point?
Lordship. Yes, that is premature, and Supreme Court in this judgment has come that if it is
So nothing else matters whether notice was properly served.
or not. Once it's a order of taking cognizance is irregular, so that will not be taken into consideration now because it was premature. So Supreme Court has come up with a solution that he has complained maybe.
We will dispose of this in
Yes,
front
Lord,
of the
we may
Supreme
be
Court.
able to withdraw the complaint and we'll file the fresh complaint with
That is well, they are.
and my delay will be controlled because of the irregularity in taking cognizance.
I heard learned counsel for the petitioner. Also heard that counsel for respondent, sole respondent. Learned counsel for, learned counsel for the respondent fairly concedes that the order of taking cognizance, which is under challenge in the instant petition, is erroneous in view of the decision of the Honorable Supreme Court in Yogendra Pratap Singh versus Savitri Pandey and another 2014 10 SCC 713 and Gajanand Buranje Burange versus Lakshmi Chand Goyal 2022 Live Law SC 682 and accordingly submits that as per the aforesaid decisions, the respondent stroke complainant may be allowed to withdraw his complaint and file press complaint as may be permissible in view of the aforesaid decisions. Accordingly, the instant petition is disposed of on the aforesaid terms.
My lord, that quashing order may set aside, my lord. Sorry, my lord, that cognizance order may set aside, my lord.
Which order?
Order of the cognizance, my lord.
Taking cognizance.
Yes. Maybe withdraws it anyway and goes.
My lord, if they not be withdrawn, then order dated 29
It
to
is further
24.
provo-
Case 27, my lord.
Yeah, the order dated, you see page 27, order dated so and so, passed in so and so is hereby satisfied. Total line to DD.
Obligement.
Yeah, please, Your Lordship. Well, it's a quashing petition of affair, my lord, in the entire procedure, my lord. Of course, it is case of NDPS, my lord. Even then, my lord, I take your lordship, the primary FSI, my lord, there is no case against that. I take your lordship, NDPS. Annexure 1, page 17, my lord. My lord, I am owner of that vehicle, my lord.
You are seeking aside, setting aside of the NDPS proceedings.
My lord. My lord. No, my lord.
All right, then we will have to hear the matter fully.
My lord, here,
lord.
NBW was issued against him, my lord.
My lord, because of
Thereafter, my lord, it was, next date was 28/7/2025 for appearance and report, my lord. Thereafter, what is happening, my lord, that is not in the reveals in the record, my lord, as it was received earlier, my lord. In the meantime, Lakshmi also called for the up-to-date, my lord, status, my lord.
My lord, I am the owner, my lord. Actually, the main accused, my lord, those from whom the possession was, my lord, the contraband was received, my lord. I being the owner of the vehicle, there is a apex court judgment. I have no knowledge.
21.
My vehicle was one of the relative taken back. Next day morning, I
These
kept
are questions of facts. It
My
can
lord.
differ
My
from
lord.
case to case.
My lord,
So,
your lordship kindly peruse, if your lordship peruse the record, my lord. I have been charge sheeted because of absconder, my lord. I have been all on appearing, my lord. My Jimba vehicle was released, my lord. My lord, from the records, my lord, trial court records, my lord. So where is the question of absconding, declaring me when I have been regularly visiting the officers for getting the vehicle, my lord? It is only because of by filing of the Jimba petition that was released. And there is a judgment of this honorable court, my lord, police can have no power to, my lord, declare the absconder, my lord.
It's different thing, my lord. That's why I am saying.
No, that is the thing, my
report,
lord.
my lord.
Because of
If
the
it was
absconder,
declared by absconder my lord, court also.
no,
my lord.
by virtue of the abscond in the charge sheet, my lord, I have challenged that charge sheet.
That's why it was up to date status report is required, my lord.
That is only because of the my NBW was issues. This is the update, my lord. Your lordship, if my learned friend so, my lord, that may be called for, but yes, your lordship.
Alright,
Fix the short date, my lord, because of
The prayer of
there is a
limit,
judgment of the Supreme
additional
Court. my
PP,
lord.
call for the updated,
Petitioner should not be suffered with unrecognized.
updated.
Status of the case.
No, not is yes, updated scan copy of the.
Alright, updated scan copy of the TCR. Up to, this is up to what?
And that is up to my lord 24/7, 24/6, my lord, 25,
From 24,
2020.
then 26.
Last order was my lord 24/6, 2025. Last 7 months.
Of NDPS case number 4/2025. From the special judge Silchar.
Special Judge NDPS Silchar.
Well,
Hearing, my lord, so that on that day, my lord,
Please the matter
for final hearing, my lord,
for hearing.
5th of February. My lord, highly obvious.
no, no.
May I please, Your Lordship? I have challenged the order, judgment and order of the family, learned family court, Lordship. At this stage, I am praying, if both the parties appear before the mediator, then we can settle it outside the court in between the mediator. And one order was passed by this honorable court to stay the execution proceeding. In that respect, we have arranged the money but unable to pay because of the bank account of the respondent, Lordship. We have also approached the family court for payment of that amount, but they have already sent back that record.
But today I have appeared for the first time. My learned friend may be served a copy, my lord. I have no copy of the.
I'll serve.
Just file, I have the color now.
But first serve the copy, then we'll
Okay, Lordship.
consider for mediation.
Next
Had
week-
learned counsel for the petitioner. Learned counsel has also entered appearance for the respondent today. Copy of the petition be furnished upon learned counsel for the respondent within 3 days. Place the matter again on.
Interim order first may be continuous.
Well, interim order passed earlier to continue
Right.
till the next date of listing.
Right, Lordship. Right, Lordship. So the application 528, Lordship. And 528 and rat with 482, Lordship. So herein, Lordship, the NBW issued by the JMFC and that part has to be recalled, Lordship. So NBW issued, Lordship, the page 38, Lordship. The allegation 395 and 397, Lordship, the robbery and Dokaiti, Lordship.
PCR is received.
Yes, Lordship.
We have received the trial court record, my lord, but I have checked, my lord. Yes, there is not available, my lord. That part is not available.
Last question call for TCR.
All this here, trial court record, but orders are there, my lord. Only orders are there. Check, my lord.
This is challenging the NBWA.
Yes, Lordship. Lordship, what happened here in this case, Lordship, there because the 10 number accused, Lordship. So the 5 number accused on large on bail, Lordship. And even though, Lordship, the petitioner name has not been reflected in the FIR, Lordship. And also, Lordship did not call for investigation during the investigation period, Lordship. So, Lordship, the summon received, Lordship, in the year of, Lordship, the 2025, Lordship, 24/5/2025, Lordship.
So the 2 kilometer distance from the PS course, the police station lordship. So invest did not call for the investigation during the admission period lordship. So the petitioner name has been reflected in the affair and subsequently include the name of the charge sheet lordship. So here in the petitioner is absolutely
As soon as
innocent.
absconder in the search.
Call for the NBW and I may allow to appear before the trial court lordship, have trial lordship.
All right, let him appear. We'll
Let
set
him
aside the
appear,
NBW and direct him to appear within a certain period.
Final. And
Hard
the
learn-
court below will consider as per law, my lord.
Hard learned counsel for the petitioner.
With enlargement bail lordship.
No, bail.
On an additional PP. This petition has been directed against the order dated 6/11/25, whereby NBWA was issued against the petitioner by the learned CJM Nagaon.
Not
That-
committed lordship.
Huh?
Not committed lordship. And the session court already rejected the bail application lordship. Order
No,
dated
no, we are
20
talking about the order of NBWA.
NBW.
NBWA is issued by
Yeah,
CJM Nagaon.
JMFC lordship Nagaon. Page 38 lordship.
JMFC, you have written CJM. Head of CJM, right? JMFC Nagaon. PRC case number 1582 of 2022. It appears that after completion of investigation in the case, the police had submitted charge sheet by showing the present petitioner as an absconder, because of which the learned court below had issued the NBWA against the petitioner. Further submitted that the petitioner was never called by the police during the period of investigation, and his name also does not appear in the FIR, and the petitioner had no knowledge about the charge sheet having been filed, showing him as an absconder. Having heard learned additional PP, the instant petition is disposed of by putting aside the NBWA against the petitioner, wide impugned order dated 06/11/2025 in PRC case number 1582 of 2022. And directing the petitioner to appear before the learned JMFC Nagaon in a period of 15 days from today. File appropriate application.
Sir.
Which shall be considered by the learned JMFC Nagaon. Petition stands disposed of.
Fine. Much obliged. This is a session tribal lordship. CGM can jurisdiction enlargement bail lordship. It session tribal lordship. Not committal.
Get committed. Okay, but we have set aside the NBWA.
My lord, because someone issued from the judicial message.
Yes, Lordship, yes. Lordship.
May I please, Lordship? This is a customs, NDPS case. We have challenged the extension order. What happened, Lordship? We had filed a bail application before this honorable court during the pendency. When the statutory period was supposed to be over, they filed an application for extension of the statutory period. And by the impugned order, it was extended, and it will be extended for 90 days. And the 90 days will be over on 27th, Lordship.
My senior is not adjourned the matter for it. Other is undergoing eye surgery, Lordship.
22nd, Lordship, because on 27th, 90 days will be over. We are challenging the extension was illegal.
Why is the order illegal?
Lordship, 36A4, special public prosecutor.
Report of special
Yes,
public
report. There
prosecutor.
should be
That
report.
was not there.
There is an application. There is no report. Our submission, this is not a report, this is an application, and there is no application of mine. He just reiterated whatever IO has stated. This thing is on why the further custody of the accused is required. It is also not there. There is no application of mine. And notice was also not issued to the accused person. As per Lordship, three judges' decision.
So 90 days is going to expire on 27
Yes, further 90 days was supposed
this
to be.
month.
This month. So,
2 days they are going to file charge sheet, Lord.
if it is illegal, then we will be entitled for default bail, Lordship. That's why that is the important thing.
But if your 90 days has not expired, how are you entitled to default bill?
No, for 180 days was over. Now extension. Further extension is going on.
That extended period is going to be over.
Yeah, yes. Extended period is going to be over on 27. Notice was also not issued to the accused person. They are in jail, not to the relatives. But learned national judge on the last part of the order mentioned that a copy of the application was served upon counsels. Now, in investigation stage, even if there is a previous application for bail and rejected, a counsel, how can a counsel?
Oh, even if it gets over, we are only on the next date. When can you appear?
23rd to 24th.
23rd.
23rd is holiday, I think. 22nd.
22nd.
Lordship.
Thursday.
Matter again. 23rd.
Highly obliged.
Item number 25. In this case, petitioner is in interim granted on 25/9/25. The PM report received earlier also, my lord, cases pending since long, my lord, that till today also, my lord, FSL report not yet received, my lord.
Lord, or my lord, bail may be made absolute, my lord, because my lord, considering the circumstances, my lord, the petitioner father is a mentally ill, my lord. And now I have been informed that he is, since 2 months, he is in hospital. And my lord, his mother also, my lord, died, my lord.
FSL report is regarding what?
My lord, allegation is that, my lord, that petitioner my lord, deceased person has not committed suicide, but my lord, decision, my lord, allegation is that my lord, the accused persons involved in committing murder of the deceased, my lord. Otherwise,
Let us see the PM report.
PM report, yes.
It is a case of suicide, my lord.
Marriage solemnized between the parties on, my lord, in the year 2023. Incident occurred in the year 2020. In 2 years of marriage. My lord.
Its oblique non-continuous ligature mark is there, prima facie indicates suicide. Learned counsel for the petition and learned additional PP. Special report as called for has not been received. For the what second time today?
Well, earlier case,
Not second time, my lord.
my lord, is fourth time.
After entry, my lord, fourth time.
For the fourth occasion today. The FIR dated 11/7/25 was alleged by the sister of the deceased that the present accused was married to the deceased and his family members harassed her. Ultimately, her body was found hanging from a ceiling fan, and it was suspected to be a case of murder. The FSL CD along with the PM report has been received where the opinion regarding cause of death was shown as kept pending due to non-receipt of FSL report. Perusal of the CD, it is seen that there is some implication. Who is the petitioner here?
Deepu Das, my lord.
He is the husband of the deceased.
Husband of the.
Implication of the
Husband of the.
petitioner. Then you go to paragraph 6 of order dated 25/7. Order on perusal of the post-mortem report. It is seen that it has been mentioned that an oblique non-continuous ligature mark was present high up around the neck above the level of thyroid cartilage, which is prima facie indicative of suicidal hanging. Having regard to the above, the prayer for bail is allowed. The order of interim bail dated 25/9/25 is hereby made. Petition stands disposed of. Send back the CD.
Obligement.
May I please the lordship, my lord, this is a 483 application. The petitioner is in custody, my lord, for last about 48 days, my lord. And it is a 7 years offense, my lord. The FIR it has phase 14, my lord. Petitioner is not named in the FIR, my lord. As per the allegation, my lord, the petitioner's involvement is that, my lord, the stolen articles were sold to him. And police accordingly, my lord, arrested the petitioner and seized some of the articles from the petitioner's shop, my lord. That is, my lord, seizure list at Annexure 2, page 22, my lord. The petitioner is have a jewelry shop, my lord. And my lord, the allegation is that stolen articles were sold to the petitioner, my lord.
You are the receiver of stolen property.
My lord, that is only, but my lord, he is not directly involved with the offense, my lord. The receiver of the store, and normally whenever, my lord, he is running a jewelry shop, when he got something at a lesser price than the market, that is his offense, my lord. I understand, my lord, but now as of today, he has completed 48 days in custody, my lord, and it is a 7 years offense, my lord. So considering his detention and since his statements have been recorded, some articles have been seized from his shop as well as his residence, my lord. So his further custodial interrogation is not necessary, my lord, at this stage, my lord. This is my humble submission.
Heard learned counsel for the petitioner. Okay. This is an application under paragraph 3 of the petition. The IO arrested the main accused, Sahidul Ali, who led the police to the jewelry shop of the present petitioner, where some of the articles were recovered. It is conceded by learned counsel for the petitioner that the petitioner, being the owner of his jewelry shop, had purchased the stolen articles below the market price from the main accused. The only prayer, only submission is that having regard to the length of detention of 48 days. The prayer for bail may be considered. In regard to the fact that the investigation has progressed as far as the present petitioner is concerned, and articles have also been recovered. Considering the length of detention of 48 days, the prayer for bail is allowed. It is directed that petitioner shall be released 1 lakh with securities like amount.
Chief J.M. Kamrup Metro, madam.
Connection with the aforesaid case, provided that the petitioner shall try to tamper with the evidence or influence the witnesses. Petition stands disposed of.
Chief J. applied.
May I please, Your Lordship? This is for 83 bail application matter. FIR is case 11 madam. The petitioner is judicial custody since 25 November madam. 56 days in the custody. Madam.
56 days.
Yes, ma'am. Allegation is 379 madam. Case is of 2018, my lord. Petitioner was arrested on 25/11/25, and my lord, the habitual offender. Other cases also pending against the accused. One Manikpur PS case number 159/24, Manikpur PS case number 76. And the vehicle, my lord, stolen vehicle not yet recovered. He is the person, he sold the vehicle to someone, my lord. Yes. Let us per case number 20, my lord. The other vehicle, my lord. If the stolen article have been recovered, my lord, already.
Covered.
The vehicle not yet recovered, my lord.
But it is 56 days.
Yes, my lord. Only on that ground, my lord. Other-
Is 19 of. In detention since
25/11. 25/11, my lord.
25/11.
2025. Present 266 days. Sir.
Where do you say stolen article has Bolero has been recovered?
It's annexed 3, my lord. Tata diye.
But is it the same case?
Same case, my lord. Co-equal.
4/18. There is an observation in that order. It has been recovered.
I think next fact one, three, yes, 20. Yes.
Page 20, first line.
So only it is mentioned that stolen articles recovered. But here, my lord, in the recent, my lord, that is note of the IO bail objection, my lord. He specifically mentioned that, my lord, not yet recovered, my lord. In that order, my lord, specifically regarding the vehicle.
If it is recovered, there will be a seizure list
Yes.
in the CD.
No, my lord, seizure list is not there in the city.
Not there.
I will have to check, my lord. After some time, my lord.
All right, will not, that part we omit, stolen articles recovered part.
Not yet recovered. CGM Congress.
নালাগে হ'ব গম পালে ক'ব
So our names are not showing in the cause list, my lord.
This cancellation of bail lordship granted by the learned additional session judge.
is submitted that the name of learned counsel appearing for
Opposite party number 2.
party number 2 is not shown in the cause list. Hence list the matter again on
Next week, any date, my lord?
showing the name of
A. Ahmed. Mr. A. Ahmed.
so and so in the respondent column of the cause list.
Lordship, here CD is not available.
Up to date case diary not received, my lord.
Up to date
Earlier
not
CD was
received.
available but returned back.
List again on.
After, my lord, to the-
When?
But 3rd of February.
Received.
No, my lord. CD not received.
None appears. CD also not received. List again on. Spencer interim order passed earlier to continue till the next date.
On 11th of February.
But here we have received a case diary, my lord, but not received a report, my lord, whether after interim they have appeared or not, my lord. That report, that regard, I pray for tomorrow, my lord.
Here is an order, my lord, on 12/8. In that order reflected the statement is available. The case
No, my
diary
lord,
for
that
the
is-
petitioner number 1. For the petitioner number 1, in respect to the petitioner number 2, my lord, here is.
Let him get the clarification then.
My lord, my lord, my lord.
Release the matter
That is
again
the after 41 notice level.
tomorrow.
My lord, tomorrow.
In order to enable learned additional PP to obtain instructions.
Whether they have appeared or
Whether
not.
the
After interim.
petitioners have appeared before the IO.
Here may be continue.
Passed earlier to continue.
Lordship, kindly matter may be pass over for the day.
But here, as per information, my lord, charge sheet submitted, my lord.
Prayer of learned counsel for the petitioner. Is the matter again on so and so. The order passed earlier shall continue till the next date of listing.
Next week or the day?
Publish.
Time being possible. Acer Sudhir will the case lordship. Put number 1 is standing.
It is received.
36 my lord. Scan copy my lord. Scan copy.
Time being lordship.
CD.
Seniorism.
CD not received. Interim order passed earlier to continue to next date of listing.
Letter did from Kamrup Metro itself, my lord. February 28th February. 28 to. Item 40 also CD not received, my lord. They are interim, my lord.
CD not received.
40.
Interim order passed earlier to continue. Again on.
22-0. 22.
My lord, I have a prayer, my lord. In this case, my lord, one item, my lord, is fixed before in court number 8 today, my lord. Item 45. And the CD is lying there, my lord. So we can wait for this case, my lord.
Then fix any other day, my lord. No.
Today, my lord. Maybe, my lord, today, my lord.
Not possible, my lord. It is in the
Ah.
another court, my lord. Then it will come.
My lord,
Let's have it day after tomorrow.
day
Then.
after tomorrow.
After.
Is submitted that the CD of this case before another court connection with the same FIR. Hence list the matter again on
21.
Wednesday.
Much of it.
My lord, item number 39. My lord, interim
Interim
order.
is there. I have already informed.
My lord, CD has not come, interim to continue, my lord.
Interim order.
Resubmitted.
My lord. CD received, my lord.
$42 somebody mentioned, I think.
42.
Is mentioned.
Mentioned in morning. Mentioned.
Ma'am, please allow, sir.
42.
No, 41 or interim to continue. There is an order, my lord, interim, my lord. Interim may continue, my lord.
Where?
Item number 41, my lord.
You fall asleep.
It is fixed for day after tomorrow, my lord. There is an interim order, my lord, for one petition. my lord.
Yes, what happened when 41 was called out? Were you asleep?
No, my lord, we forgot to mention, my lord, that my lord, the interim may continue, my lord, in that matter, my lord.
I think we have done this.
Number 1. Item number 41, my lord.
41
Petitioner number 1, my lord.
interim.
FR page is 9, lordship. The allegation is kidnapping, lordship. After the filing of the FIR lordship, the investigate the case. During the investigation, lordship, the police has arrested the wife of the petitioner, lordship. petitioner filed the bail application before the learned session judge. Lordship. The session judge, Lordship, CD was called for, and the CD, it is reflected the victim is already recovered. The recovered means, Lordship, the fact of the case is, Lordship, is the friend of the accused petitioner. Money, he promised to return them, Lordship, but he has failed to return. On the Alice Day, Lordship, he was meet the victim, and the victim request him to allow him.
Is this Rajneesh Kumar? He is the victim.
My lord, he is the victim, my lord. He
His
was
bail
taken by the
application was
present-
filed by him in before the session judge.
But his
My lord, initially he was kidnapped for ransom, my lord.
Lordship, they are
But thereafter he was recovered, my lord. He went to the Bihar, my lord. Thereafter he came in a statement given, my lord. And from the statement, it reveals, Lordship kindly reads the statement of the, my lord, victim. There, my lord. Some injuries are also there, my lord. When he was taken to the house of the, my lord, accused person, he fled away from the house, my lord.
para 5, Lordship, I have stated 12 fact, Lordship.
I think CD is very much clear. It is reflected in the order of the session judge also. You are caught on CCTV footage.
Wife also said that, my lord. Taken to his house, my lord. And thereafter taken to the house of the another person, my lord.
They dispute, Lordship, that the money is.
Then the caretaker also said, my lord, that line also.
Third, learned counsel for the petition and learned additional PP. Two of the bail, and this is an application on the defense. Paragraph 2 of the bail petition. Learned additional PP has produced the case diary. From it appears that the CCTV footage has clearly revealed the role of the present petitioner, the kidnapping and confinement of the government. Further, the witnesses have also implicated the petitioner having regard to the incriminating material available in the CD as well as the gravity of the offense. The prayer for pre-arrest bail hence rejected.
Please, Your Lordship. Lordship, here the petitioners are on interim, Lordship.
Both cases, my lord, search sheet submitted, my lord. Present case is, my lord, Polaigaon PS case number 8324. One cost case also, my lord, file, and in that case also CD was called for. In both cases, search sheet submitted, my lord.
Which is the other case? Item?
Item number 58.
No, there are two FIRs. Family dispute cross FIRs are there. And that FIR is at page 15, FIR number 84/24. Filed by the petitioner number 1, Lordship, against the informant. I am seeking bail in the earlier one, that is 83/24. And in that case, interim has been granted by this honorable court on 17/3/25. 83 more bail.
Third learned counsel for the petitioner and learned additional PP. This is an application under so and so in connection with. Learned. There are two. Submitted by learned additional PP that charge sheet has already been submitted in the present case. File CS number 10/25 dated 9/3/25. Having regard to the fact that the prisoners are housewives having children, and this court had granted pre-arrest bail, interim pre-arrest bail to the petitioners. Considering the fact that the investigation is long over and it was also filed way back on 9/3/2025. It is not necessary for the petitioners to be taken into custody. Accordingly, the order of interim pre-arrest bail is dated 17/3/25 is hereby made absolute. The same terms and conditions. Bail petition stands.
Oblige, your lordship.
Item number 59, my lord, petitioner is in interim, my lord. My lord, here in the case there is two medical report available, but my lord, earlier, my lord, one final medical report from neurosurgery department was called for, my lord, that not yet received, your lordship may kindly tell. But final medical report, my lord. This is also, my lord, pending since.
Mentioned that patient came with serious injuries.
And thereafter, my lord, one medical report of GMCS is also available in the. That report, it reflects that, my lord, final report from neurosurgery to ascertain the type of injury. Laceration is there, my lord. Otherwise, victim statement is also available in the same.
Call for the final report then. Because neurosurgery report may reveal something else. Final medical report is not available. In that the same was called for earlier also. But till date, the said final medical report is not available. IO is directed to in the same and submit.
Petitioner is in interim. I may be allowed to return back the CD for of this one, my lord.
It before the court on the next date
Interim.
fixed. The interim order passed earlier shall come. CDB returned for resubmission on the next date. List again on.
After some time, Mr. Mahajan is appearing now.
It is there.
How like?
May I please, lordship? Lordship, the petitioners are on interim and they have accordingly appeared before the recorded stage.
We have received the CD, Lordship. I have gone through the CD, but Lordship, here in this case, Lordship, I have not found any direct implications. This is a snatching of chain, Lordship, matter relates to. The only implication that why they have been wanted, that is earlier they have been arrested in another cases, in such kind of a cases, Lordship. The implication is nothing else, Lordship, I have not found.
At 18/12, 8/12, 08/12. Third para. CD as called for has been received. And it is submitted by learn. There is no direct implication of the present petitioner. Para having regard to the same, the order of interim pre-arrest bail dated 08/12/25 is hereby made to look the same conditions. Petition stands disposed of.
So, please, Lordship. Item 62, we have received the CD, but it's such kind of voluminous.
May I please your lordship, as per direction of the Sonarbul Code 3/12/2025, I have appeared before the IO on 9/12/2025 and 24/12.
Well, let him go through the CD, we'll have it tomorrow, day after.
After tomorrow, Lordship. Or 22nd, Lordship.
CD has been received, which is voluminous, and additional PP, seeks some time to go through the same, hence list the matter again on. Yeah, give it.
Yeah, well, definitely.
21st. Obliged.
Interim order passed earlier to continue. Interim is there. Before mention is anything. Mention is.
They will not teach us.
Please, your lordship. I'm praying for first of all the matter, lordship. The conducting council is out of station, lordship, in this matter. Lordship. Interim is there, lordship.
Prayer of learned counsel for the petitioner, list the matter again on. So and so interim order passed earlier shall continue till the next date of list.
Much obliged. May I please, your lordship. Order dated 8 December 2025, matter was fixed for instruction. This case has been charge-sheeted or not?
So
8/12/2025, 46.
Should I make, no.
As per office note, AD card or answered notice in respect of respondent number 2 has not been received back.
Here in
Is
this
the
case,
matter-
charge sheet may not be filed, it is not filed, Lordship, because Lordship, we have the CD, Lordship.
Is the matter again on so and so.
CD we retain, Lordship.
But return,
We may retain, Lordship.
retain. CD received be retained.
Yes, while senior have some medical appointment, he will be available after the second half, my lord. At 2 lordship.
2 I have to be available, my lord. My one title appeal is to be parted in the district judge court. What I pray, my lord, they filed an IA for vacating the stay order. Now it's a criminal petition, my lord. The entire matter may be disposed on a fixed date. Because
After
the
tomorrow,
scan copy also received by the Honorable Court, my lord.
After tomorrow, lordship.
And service is also completed. So let the matter maybe on the March, my lord, any day fixed. The infighting between the members of the society, my lord. No marpit, nothing.
So you are on interim protection.
I am for the petitioner, they are the.
You're standing on the wrong side.
Yes, yes. So I have to shift here because of the IA, my lord. Because of the IA.
You
I
are
have
the
to
applicant
hear.
in the IA, lordship.
They are the petitioner. in the
Let's have
IA.
it day after tomorrow.
Day after
Since he's
Okay.
The player of Learned Counsel for respondent. List the matter again on
21st. Fine.
interim order passed earlier.
Lordship,
Continue.
my senior is busy on another court. Kindly take the matter after some time.
Hmm? None appears. List again on so and so. Interim order passed earlier to continue.
This matter, your lordship was pleased to call for the CD of the case. CD we have not received, lordship.
So did not receive. List again on so and so.
Can it be on
For
fifth?
respondent, also, we have submitted the color number today.
Akalatnama has been submitted on behalf of respondent number.
One.
Can it be on fifth, my lord?
All right.
5th February. I'm obliged.
May I please your lordship? Lordship, I'm appearing as a legal aid counsel in this matter. Lordship, this has in file under section 5 of the limitation act. There is a delay of 238 days in filing the connected criminal appeal. The delay is occurred as because the documents connected were not supplied to me. Thereafter, it has taken some delay. The case was handed over to me on. Lordship will find it page number 5, paragraph number 5, 16/7/2025. Thereafter, from perusal of the document, it came to my knowledge that deposition of the witnesses and connected documents were not available. And thereafter, they were supplied to me from the district, Kachar district DLSA. Thereafter, it has been filed, and that has occurred the delay. Poksot. Misal.
Okay, legal aid counsel is there. Will pass order. Let me.
Oblige, Your Lord.
I dispose of.
Item number 53 and 54, my lord. State has filed this revision petition challenging the order of the trial court granting Zimma of the vehicle in NDPS case. My lord, the accused persons in whose favor my lord vehicle was granted
53.
53 and 54, my lord. Here one delay condemnation petition is also there, my lord. Delay of 78 days, my lord.
None appears.
No, my lord, today
No.
state has filed this.
State has filed
State
this.
has filed this. petition. One delay condemnation petition is also there, my lord. Because the accused, the
Notice is to go. Notice.
delay may be, my lord,
How?
the main case, my lord, may come up.
How can you dispose of without even a notice?
Because, my lord, in view of the, my lord, Supreme Court decision in Biswajit Dey versus State of Assam, we are challenging on that ground because the accused person my lord, they are search sheeted accused in the NDPS case, my lord.
Hmm.
And in my lord, they have filed application before the trial court and the vehicle was granted.
Whatever be the case, they have to be heard,
Otherwise, my lord,
learned additional PP. This IA has been preferred, seeking condonation of delay of
78 days. my lord.
78 days in preferring the connected appeal. It is to the sole respondent. Steps within 3 days. List again on I can give same.
Before same, my lord, 4 days, delay of 4 days, my lord. They also, my lord, accused, my lord, petitioner, he is the
Same order.
Lordship, tomorrow or day after tomorrow, Lordship, on late number one.
Already. After tomorrow. Prayer will-
Okay. May I plead, my lord?
Hmm.
My lord, actually, my lord, the respondent number 2, the beat, block development officer of 22-23 batch had made certain allegations against me. They've been mentioned, my lord, forgery and fraud, my lord. But my lord, this is not true, my lord. My lord, if I may kindly direct your attention to Annexure 1, my lord.
Service complete হচ্ছে না today is for orders. Order service complete order.
Why to actually late
Post one है.
office not to let it.
Not complete, I think.
Not complete perhaps.
Notice issued upon respondent number 2 has been received back unserved
Right.
with remark that addressee has left.
The last occasion also Lordship was pleased to call for trial court record and CD.
My lord, the interim
That perhaps also not received, my lord.
As far as respondent number 3 is concerned, neither ID card nor any unserved notice has been received back.
My lord, interim protection may be given to my lord.
Right.
Petitioner to furnish present address of the respondent number 2. And take steps accordingly. Scan copy also not received.
Not received, my lord.
Scan-
This year.
Although scanned copy of CD along with TCR was called for by order dated 12/12/25 from the learned CJM Dhemaji, the same has not been received. Reminder. List again on
Obliged, my lord.
May I please, your Lordship? Lordship is still at lag at port number 23, so if possible tomorrow or day after tomorrow.
day after tomorrow.
Interim order earlier granted may continue.
They have to come out.
CD to period, madam.
CD receipt, CD retained.
Interim order.
Easily to. Still नहीं? APR করছে একটু। কোনো অহা নাই, অহা নাই। নাই নাই তেতিয়া মাতোতে অহা নাই।
I thought my lord, that matter was already disposed.
I also think so. Just a moment, where is the FIR? Yes. Oh, it was that part. I asked you to look at the CD whether stolen vehicle has been recovered or not.
Yes, that. My lord, as per recent notice, Caesar list also I have not found in the case diary, my lord.
Alright, we have disposed of.
Yes. My lord, your lordship, may your lordship, if your lordship permits, my lord, item number 53 and 50, may I be allowed to take a step also through the police station, my lord?
I have not mentioned anything.
Yes, I may also be allowed to also to take the step through the police station, my lord. Additionally.
Take steps, usual manner and also through one police station.